Good afternoon. I just came across a colleague of mine in one of our large LinkedIn groups for Social Security disability professionals. It would include representatives like myself, attorney reps, non-attorney reps, ALJs, retired ALJs, I think it would be mostly, um, SSA staff, DDS staff, vocational experts, and I think occasionally a medical expert. Anyway, there's like almost 3,500 people in this group. It's across the country. I have the privilege of managing it for the owner since about 2011, I think, when she asked me to do that. Um, anyway, this particular member of this group who does a really terrific job analyzing court cases that come down in various circuits. And I've mentioned one or two before. Um, her name is Adriana de la Torre. And I could be saying that wrong, so I apologize. Anyway, she did a really fabulous job. And I just wanted to go over with some of you that this might be pertinent to, because it has to do with how an ALJ can reasonably somewhat disregard or evaluate in a way that you don't find favorable to yourself your claim of how your pain or your medications affects your ability to concentrate and focus. Because as some of you might know from other videos, particularly for people in the grid area over 50, our mental capacity, even when not horrifically deteriorated, but even just kind of mildly or moderately, and we're still functioning human beings, we just can't necessarily do some high-skilled stuff like we used to, maybe transferring skills, etc. This was a Ninth Circuit case. It just came out in December of 2023. Went versus the SSA. I'm just gonna leave it at that. They use the commissioner's name, but I'm gonna butcher it, so I'm just gonna leave it alone. Anyway, the defendant was obviously arguing that back pain and the side effects from medications limited the concentration that he could muster up in a work day, a full work day. And the ALJ in that case apparently found that the medical evidence was inadequate to support these claims. And it drives home the point, guys, that medical evidence, can you hear Elsa barking? Medical evidence is what is going to be the foundation of any kind of finding. You can't just say, even though I thoroughly believe it, because I know chronic pain will do a number on your concentration. Absolutely. In addition to other impairments, doing it from a more organic point of view, just coping with chronic pain is a concentration buster. However, that is not sufficient. Just our common sense knowledge of this, because for other people, they do deal with pain and do high-end jobs. Some, it could be very high-end jobs. So it really depends on the person. So in this case, apparently the court discussed that the claimant's only evidence of his limits to concentration were the self-reported symptoms. So he was probably claiming it in testimony or in a function report, which wouldn't be bad, except that he had not even sought treatment for these symptoms. Now, for my clients that know me and people who have been paying attention here, I'm constantly telling people, if you've got issues with concentration and focus, which you probably do, sometimes anxiety is a huge one also. So even if you're not a chronic pain sufferer and that's not your impairment, but you have the mental struggles of significant anxiety or moderate anxiety, that can do a number on your concentration in terms of, can you concentrate for an 8-hour day or 2 hours straight without interruption and absorb, all the things you have to do when you're concentrating. I always say, start getting that looked at so that it's documented that you're getting treated for it. It could be talk therapy. It doesn't have to be medications necessarily. So this defendant had not sought treatment for these symptoms at all. He just claimed them, and there was no medical evidence to support their existence. That's pretty significant. When they say no medical evidence, and I didn't read the decision yet, so I'm going off of a summary that was kindly put out by this fabulous lawyer who does a great analysis every time she does this. She also notes that there's a reliance on multiple factors that the lack of consistent effort during the evaluations and loss of work unrelated to the alleged disability. So different things supported it. Apparently the ALJ in this case noticed there was a lack of consistent effort by the claimant, claiming that there was interfering concentration loss. I mean, if there's interfering symptoms of any kind, that's what we always say, go get it looked at, go get it followed, because that is what's going to be the evidence that brings your case to fruition. And without it, you might find yourself like this unfortunate fellow or gal, I'm not sure which. And of course, as you know, the ALJ has great discretion on how to weigh these things. This is not something that just because it's even if it's found in the medical evidence, if there's reason for it to be not credible, maybe there's inconsistencies, whatever, the ALJ has broad discretion on how to weigh that evidence in terms of whether it's persuasive or not. Largely, he has to, discuss how he did weigh it and what led him to that. But the point is, he or she has that discretion. And the court recognizes that, obviously, in this case. She goes on to say that I guess the claimant thought that there should be specific, clear, and convincing reasons for discrediting his symptom testimony. But the court pointed out that, and she quotes, although the reasons were not all articulated in one place in the ALJ's opinion, we look to all the pages of the ALJ decision. So obviously there were little spot comments by the ALJ throughout the whole decision, rather than just a paragraph that addresses specifically. And they found that to be enough to carry the weight that the ALJ has to carry in discrediting the testimony. Because of course he does have to consider the claimant's testimony, for sure, even without the medical evidence. But obviously without medical evidence, it's not going to go far. But also if there was reasons why the testimony itself didn't seem very clear. And honestly, and I can't emphasize it enough, the failure to treat. If you don't treat your symptoms like you have them, why should anyone believe you have them just because you say them? Guys, talk is cheap. Talk is cheap. You've got to walk the walk. This is so true in every part of life when it comes to credibility. We talk about this all the time in other areas of life, right? Whether it's work or politics or whatever. When people don't walk the walk of what they're talking, what they say just doesn't hold a lot of water. And not too many people believe them, except for the very naive, perhaps. There is a little bit of narrative here about the past work assessment. Apparently, the VE found that the claimant here could work as a circuit layout technician. Circuit layout technician. Despite technical advancements that have probably occurred since this guy, apparently, guy or gal, previously engaged in similar work, I guess. And again, I haven't read it, so bear with me. And that VE expert did acknowledge industry changes, but still supported the claimant's potential to work as a circuit layout technician. Don't even know what that is. I'll have to look it up. And the court validated that determination, noting that, quote, the expert described that conclusion as a, quote, very close call, but the testimony is nevertheless substantial evidence sufficient to support the ALJ's conclusions. Okay, so all these little nuggets of where this case came to be a denial those are those crumbs that I'm always talking about. If, it could be that had he taken that step of going for that follow-up with regard to the loss of concentration that he has, perhaps due to adjusting and adapting to chronic pain, if that was his issue, I think it was back pain. If one has anxiety or depression, and that doesn't have to be your big disabling thing that keeps you out of all jobs in and of itself, but it's got to keep you out of your past work, right? We always have to be unable to do our past work. So if Better concentration is required for our prior job, and this would be particularly true with semi-skilled or skilled work. And now we have these concentration issues that can lend itself to a finding that we can't do that past work. And you have to make that finding before you can use a grid. I know everybody that contacts me who's 50 and older goes, I can grid out, right? And I'm like, not necessarily. Have you gotten all your crumbs together? You know, have you gotten everything you need to grid out? And gotten them not to your own satisfaction, to about what might likely be an ALJ satisfaction. This is what you have to do. Okay. Anyway, fabulous. I love it when she does these. They're just so good. She's so thorough. Sums it up with noting that the court is emphasizing here the multifaceted nature of assessing alleged impairments and credibility. And that, again, is why I'm saying crumbs, 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 multi, guys. You don't hone in and just focus on one thing. This is going to get me to win my case. I always say go at it from all angles. We do it. This is the way we do it. We go after every single thing. And we tend to advise you also on the 20 different things you should be doing to make your case as close to 100% likely to win as possible, because we know that there's no such thing as 100%. But you want it to be as close as possible. You want as small a chance of losing as possible. And that is what we try to do. Okay. So this case is really informative and drives home this point. Very new case, December 2023. It's in the Ninth Circuit, but again, any circuit case is really helpful for other circuits if you're, whatever circuit you happen to be in. All righty. All right. Take care, guys. I hope it helps. Bye.